Okay, I'm going to restart. We obviously had a technical issue there. So apologies for that. So welcome to the fortnightly webinar from Visa Solutions. We're going to be covering this week a range of sponsorship scenarios in brief detail. For those that don't know me, my name's Andrew Emmett. I'm the Director of Immigration Services here. I've got with me today Fiza Ismail. Fiza recently joined us. She's a recently qualified migration agent. She's got about 5 years relevant work experience in the industry. This is the first time that she's going to have been participating in the webinar, so please go easy on us. A little bit of background about the company. We are a full-service immigration provider. We provide a range of innovative solutions for people in a wide range of scenarios. We aim to provide every client the highest standard of service at an appropriate price. If you've got any queries, flick them through to me on the chat platform, and we'll see if we can address them at the end. But otherwise, let's get cracking on with the seminar. We've only got a short amount of time. So I'm going to start off with the most common form of sponsorship, which is sponsorship by an employer when they bring someone in on a 457 visa. The 457 is the standard work permit in Australia. It's a three-stage process. The company is approved as a sponsor. The position is approved as a suitable occupation from the Department of Immigration list and so on. And then the individual is granted the visa, assuming they've got the relevant skills and qualifications to hold the position. Now, when a company has a standard business sponsorship, they agree to comply with quite a broad range of obligations. And those obligations apply throughout the term of the sponsorship. A number of them are fairly standard. An obligation to not engage in discriminatory recruitment processes, the sort of thing that would apply to an employer taking on an Australian. But there are some that are specific and reasonably common for 457 visa holders. The three main ones are the obligation to pay travel costs to enable sponsored people to leave Australia. So if you've sponsored someone to come in on a 457, you have an obligation that if they have to leave Australia and they ask you in writing to cover their cost to depart, the sponsor has that obligation to cover those costs. The requirement is that you pay for a seat on an aeroplane back to the home country for the primary visa holder and dependent family members. You don't need to pay the cost of the repatriation of belongings. It's certainly not a return trip. It doesn't need to be with a specified airline. It's whatever you think is reasonable to get them back to their home country. That one comes up fairly often. There is an obligation to provide training for Australians and Australian citizens and permanent residents. So when a standard business sponsorship is granted, the company has to prove that they've met the specified training criteria to allow them to get that standard business sponsorship approved. That sponsorship, that training obligation is 1% of the total wages bill for the last year on formal training for Australians, or Australian permanent residents, or 2% having been given in the form of a scholarship payment to a relevant training body. When the standard business sponsorship is approved, there's an obligation to maintain that training expenditure at the required level for the duration of the sponsorship agreement, which is, as I say, can be up to 5 years. That has a knock-on effect when you go on and try and sponsor your 457 holders for permanent residency at a later date, and Fees will cover that in a second. Sponsors have to tell the Department of Immigration when certain events occur. You've got 28 days to notify the Department of Immigration of, for instance, the cessation of employment for a 457 visa holder. So it's important you do that. There are penalties for breaches of any of the sponsorship obligations. So, do make sure that if one of your staff members leave, you notify the Department of Immigration straight away. You've got to ensure that your visa holder participates in the nominated occupation. They can't do something other than the nominated position. You have to maintain appropriate records, and you have to cooperate with Department of Immigration inspectors if they want to view those records in due course. As a standard business sponsor, the company is likely to be audited at some stage by the Department of Immigration, and they will want to make sure that you've been paying appropriate superannuation, the wage that you agreed to pay, and so on. There's another one which I'm just trying to see on my list, just trying to find my notes there. There's an obligation to pay any debts to the Australian Commonwealth incurred by 457 visa holders. If you've been doing it correctly and you've been paying salary and PAYG, there shouldn't be any incurred tax debt, albeit well. But if there is, the obligation falls back on the employer as the sponsor. So it's important to be aware of that, to make sure that your 457 staff are not running up enormous debts to Australia. The other one that comes up from time to time is the obligation to track down a 457 visa holder if they go missing. So if one of your employees doesn't turn up and they on a Monday and they're gone for a few days, and eventually you realise, well, they're not coming back, you need to be trying to track them down yourself, because if they've just disappeared and gone off and started working illegally somewhere else, the cost of the Department of Immigration tracking them down and then deporting them will be passed back to you as the sponsor in due course. So there are a number of important issues there. If you don't meet your obligations, the Department of Immigration has a number of actions that they can take against a corporate sponsor, which can include barring you from sponsoring other people for a specified period of time. They may take away your existing sponsorship and theoretically cancelling existing 457 visa holders. There is infringements and penalties of $10,200 for a corporate body, or $2,040 for an individual, and in some cases up to $51,000 for a civil penalty order. So it's important that those obligations are appropriately maintained. Now I'm going to pass the headset over to Fiza. She can quickly cover the complication that you get when when training criteria has not been satisfied, and you go on to sponsor someone for permanent residency.
Hi everyone, my name is Fiza. So in terms of sponsors meeting the training requirements, what we tend to find, the common scenarios that generally happens is when companies have sponsored someone on a 457 visa, and 2 years down the track they decide to sponsor the person on a permanent residence. So for example, the ENS 186 under the transition stream, that's for employees who have been employed on the 457 visa for a minimum of 2 years. In relation to the requirements for the transition stream, one of the main requirements is for the company to have met the training requirements with either the 1% or the 2% training benchmarks that's prescribed. The other scenario we tend to come across is when companies decide to renew their standard business sponsorships, and they need to provide evidence to show that they have met the training requirements for each of the year when the sponsorship was in place. Correct, that's the word. Sorry. So that's the two main scenarios we tend to come across. So it is usually best to ensure that the training benchmarks are met during each year of the sponsorship being in place. Other than that, the other one we tend to come across is sponsors not notifying the Department of Immigration in terms of changes. So even addresses or ABN changes, or if companies do tend to restructure every now and then, the department needs to be notified of those changes, and it should be done within the 28 days of any changes happening.
Do you want to also cover the sponsorship for 186 and 187 to follow on from what you've just been?
So the other types of obligations in terms of companies being sponsors is when they sponsor someone on a permanent residence, which is the employee nomination scheme. Subclass 186, there is no obligations in terms of the sponsor, but the sponsor must make a declaration that to confirm that the position is actually available for at least the next 2 years. The other one is the regional sponsor migration scheme. That is another subclass for employers who are in regional areas. There's no obligations in terms, same thing, there's no obligations in terms of the sponsor, but at the time of application, they need to make the declaration that the position will be available for at least the next 2 years. The visa applicant, however, they must make a genuine effort to remain employed in the position for at least 2 years from the grant of the visa. So I'll pass you back on to Andrew. Thank you.
Okay, I'm going to run over onto different types of sponsorship now. I'll cover partner visas and parent visas. So with an application for a partner visa, there is a visa application by the individual applicant, and there is a sponsorship by the other half, the Australian citizen or permanent resident who wants to bring in their partner to Australia. That could be for a married partner visa, it could be a de facto partner visa, it could be a same-sex partner visa, could be a fiancé visa. But there is always a formal sponsorship application that is lodged as part of the application, and it is assessed. There are restrictions on sponsorship. For instance, if the sponsor came to Australia themselves holding a partner visa, they will have a restriction preventing them from sponsoring a new partner themselves for a period of 5 years. In addition, if they've sponsored up to one previous partner in the last 5 years or 2 partners in their lifetime, they will not be allowed to sponsor any other partners. There are some waivers of that if you're in a long-term relationship, if there are children from the relationship and so on. It may be possible to get out of some of those restrictions, but that needs to be looked at on an individual basis. The requirement for the sponsor for all of those partner visas is that you agree to provide accommodation and financial support for your partner and the family for up to 2 years, or following the date of visa grant, or 2 years from first entry into Australia. If it's for the prospective spouse visa, the fiancé visa, there's an undertaking that you agree to accept responsibility for all financial obligations incurred by your fiancé, that you ensure that they comply with all relevant legislation, and they comply with the conditions of the fiancé visa. So those obligations, they're not difficult. You do need to be aware of them, and you do need to be aware that it is a separate sponsorship application process in each case. There is also a sponsorship for other family visas, parent visas, remaining relative, child visa applications, and so on. The most common of those is the parent visa, where children in Australia sponsor mum or dad or mum and dad to come to Australia as new migrants. The sponsor must be settled in Australia and must provide a written undertaking to provide support for the parents for their first 2 years in Australia. That's also going to apply to any family members who are included on the same visa application. During that 2-year period, the sponsor's got to provide support, accommodation, financial assistance as required. The sponsor may have also provided a financial bond that's done through the Commonwealth Bank of Australia called the Assurance of Support. That can also be provided by somebody else. It doesn't necessarily need to be the sponsor. But the Assurance of Support is a form of sponsorship or financial guarantee. The bond is lodged with the Commonwealth Bank. It's held with either 2 years or 10 years. And the amount of the bond varies. You earn a little bit of interest, and at the end of the Assurance of Support period, the bond is returned, less any payments that have been made through Centrelink to the visa holders. The Assurance of Support is becoming less of an issue than it used to be. It used to apply to a lot of visa categories, but still applies to the parent visa. So it's as well to be aware of that. What else have we got? Family-sponsored visitor visas. Most people can come to Australia holding a visitor visa without too many difficulties, but if you're coming from a high-risk country and you've had a visitor visa application refused, and you're in a position to, it might be a good idea to make an application for a family-sponsored visitor visa, where you are sponsored by a partner, a family member, or an MP. The sponsor in that instance guarantees that the visitor will comply with the condition of the visitor visa, including leaving before the visa expires, and takes responsibility for any financial obligations incurred by the visitor during the stay in Australia. The sponsor usually has to provide a security bond in the same way as the Assurance of Support works. And if the visitor doesn't comply with the conditions of the visa, you may lose the bond, and you may not be able to sponsor another visitor visa for 5 years. Okay. The last one I think that we want to cover is the training and research visa. I'm going to give you back to Fiza and let Fiza cover that one.
Okay, so with the training and research visas, most of the conditions is almost the same, very similar to what the 457 requirements are. Basically, you need to cooperate with inspectors and provide them with information as requested. You need to ensure that you keep records of all documentation in terms of people who you've sponsored and details in regards to the sponsorship itself. You need to notify the Department of Immigration if any changes occur. So, for example, if anything in relation to the entity itself changes, you need to notify the Department of Immigration. Any changes to the position in relation to the sponsorship, you need to notify the Department of Immigration. Time frame is exactly the same. You also need to pay costs to locate and remove any unlawful non-citizens, so it's very similar to the 457. With regards to the training and research visa, there are several streams. So one of that is the professional development. There's another one which is the occupational trainee stream, and yeah, those are the two. So with regards to the professional development stream and the occupational stream, you need to secure an offer of reasonable standard of accommodation for the person that is being sponsored. You also need to ensure that the sponsored applicant participates in nominated occupation as included in the nomination application. So you need to ensure that they remain in the nominated occupation or in the program and perform the activity that they have been nominated for. They also need to pay travel costs to enable the sponsored applicant to leave Australia. So that's the same thing with the 457, exactly the same conditions. And that is all. Thank you for joining us. So in terms of what we do, how we can help you, we understand the difficulties in terms of applications. Sometimes the stress that comes with lodging and preparing applications, documentation, additional requirements that people might not be aware of. We can assist with preparation, lodgement, and processing the visa application, even with the sponsorship as well. Basically what we do is we help reduce the overall processing time. We also assist sponsors who require assistance when being monitored by the Department of Immigration, and we understand that it is quite expensive to get anything long. So if you are refused a visa, it is quite a costly process. We work one-on-one with you to guide you through the complicated visa application process, and we give you the best chance of success. Our mission is to get you the right advice at the right price. Contact us today if you require any assistance with your sponsorship or any visa applications, and we change lives. Thank you.
Well done, Teresa. Thank you, and we'll see you in a couple of weeks. Thanks, guys. Bye.